The Government of India notified key provisions of Digital Personal Data Protection Act 2023. The Act protects digital personal data of individuals and enforces obligations on entities processing such data, aligning India's digital governance with global standards through phased implementation until May 2027. Let's begin with why this law was needed in the first place. India's digital ecosystem has expanded rapidly, creating massive volumes of personal data. Until now, privacy protections were scattered across sector-specific rules. The DPDP Act fills this gap with a comprehensive framework aimed at balancing innovation with individual privacy. To understand this balance, we look at the constitutional foundation of data protection. The Act is anchored in Article 14, Article 19, and 21 of the Constitution. Article 14 ensures fairness and prohibits arbitrary state actions. Article 19 protects freedom of speech subject to reasonable restrictions, and Article 21 guarantees the right to life and personal liberty, from which the right to privacy emerges. This understanding was reinforced in a landmark case that we know as Puttaswamy 2017 case. The Supreme Court declared privacy a fundamental right and introduced three tests for any data-related interference: legality, necessity, and proportionality. These tests guide evolution of state powers and exemptions under the DPDP Act. With this constitutional lens established, let's define some of the core terms used in the law. A data principal is the individual whose data is being processed. A data fiduciary determines how that data is handled. Significant data fiduciaries perform high volume or sensitive processing and face stricter obligations. A consent manager helps individuals' permissions and data rights. Now let's move into provisions that have been officially notified. Recent notification operationalize core process such as grievance redress, processing rules, and implementation mechanisms. They also outline phased compliance timeliness for different categories of data fiduciaries. These timeliness are central to understanding when the Act fully take effect. Compliance is staggered. Certain duties like appointing data protection officers and onboarding consent managers begin in late 2026. Large technology platforms may not face full obligations until mid-2027. This staggered rollout is intended to support smooth and realistic adoption. Next, let's look at user rights under the law. Individuals have the right to access their data, request correction or deletion, and file grievances. These rights strengthen digital autonomy and mirror global standards such as those in the European Union's GDPR. Parallel to these rights are responsibilities placed on organizations. Fiduciaries must ensure purpose limitation, secure processing, breach notification, and transparent data practices. Significant data fiduciary must additionally conduct audits and risk assessments. In case of violation, the law prescribes penalties. The Data Protection Board of India (DPBI) is empowered to investigate complaints and impose financial penalties. The board will have four members as notified and acts as the adjudicatory authority for breaches. However, there are exemptions to the law that deserve careful attention. Government bodies may receive exemptions for national security, public order, or preventing offences. Activists express concern about oversight and the impact of the right to information. The constitutionality of these exemptions will be tested against the Puttaswamy standards. Let's understand how India's law compares globally. The DPDP Act aligns with the global trends but is more flexible than GDPR regarding compliance burdens. It emphasizes interoperability for international data transfer. Despite progress, several challenges remain. Key challenges include ensuring strong oversight of state exemptions, building DPBI capacity, managing industry compliance, and safeguarding transparency under RTI. Based on this, what should policymakers and institutions prioritize? Future steps include establishing transparent exemption norms, timely appointment of board members, rebuilding capacity for small organizations, and fostering public trust through clear rules. Judicial review will continue shaping the law's trajectory. Finally, let's close with a big picture. The DPDP Act marks a major milestone for India's digital governance with the right safeguards and effective implementation. It can enhance privacy while enabling responsible innovation. The coming years will reveal how will India's framework balance rights, security, and growth.